Hello, we are back again. And this time I'm going to share my screen with the notes so you don't just have to look at me. Okay, we're doing topic 6 now, duties of representation. What are we going to cover? Basically, you need to read for this topic in Ethics, Professional Responsibility and Legal Practice, Chapter 5. That topic will be complex. It involves a conflict of the business imperative and human nature. These come into direct conflict when considering whether to represent a repugnant client. So we're going to have a look at the rules governing the question of whether a legal practitioner can decline to accept a case. We'll appreciate the ethical dilemmas of the problems posed by unpopular and repugnant clients, compare and contrast the rules that inhibit lawyers from withdrawing from a case once accepted with the rules that give clients the right to choose and dismiss lawyers, and assess the claim that there has been a shift in legal professional practice from a service ideal to a perspective based on business imperatives. So let's have a look at the duties of representation. It's the lawyer-client relationship, which involves the following duties owed by lawyers to their clients. So we've got a duty to act, a duty to inform, a duty to obey instructions, as long as they're legal, I would say, duty to be competent, duty to preserve client confidentiality, and a duty to be loyal. Many of these duties are found in the Australian Solicitors Conduct Rules and also in the bar rules. Not sure if you know who Gerald Ridsdale is, somebody I certainly would not want to be representing, hence I don't do crime. But if you're a criminal lawyer and Ridsdale came to you seeking representation, would you think about representing him or not? I would suggest you just have a look at that link there on the slide and think about, you know, are you prepared to represent such a client, the consequence of which may bring you some public disdain, some professional isolation, perhaps even some loss of future income? Would it be fair or just that such clients have no representation in the context of our adversarial system? When can you or your client terminate a retainer? And what are the implications that flow from such termination? Another example would be defending James Gargasoulis. He was the guy that drove down Burke Street in Melbourne and killed a number of innocent people. If you want, again, you can Google James Gargasoulis found guilty of murder if you want to read more about him. So there are some things that we need to consider. Duties as a part of a lawyer-client relationship, and we need to compare those with other duties. For example, our duty to the court, always remembering that first and foremost, once admitted, we are an officer of the court. We need to look at retainers and cost agreements, duty to act. Have a look at Dietrich and the Queen, a right to a fair trial. For barristers, they've got to consider the cab rank rule and the duty to continue to act. The retainer is a legal services contract between the lawyer and their client. The retainer needs to clarify the scope of legal work to be undertaken. And these things must be clear in that retainer. Who is the client and who is the lawyer providing the service? Who is in fact providing instructions? What are you going to provide? What services? What's the scope of the lawyer's authority? And what is the method that, by which way you are going to charge, and how much is it that you are going to charge? As you'll see in the topic of competence and care, the law imposes imposes tortious liabilities in addition to contractual liability arising out of the retainer. Lawyers must exercise reasonable care and skill in advising their clients. You can have a look at Hayden and NRMA 2000. Fiduciary obligations are imposed in equity. A lawyer must exercise the care, skill and diligence of a competent legal practitioner under the similar circumstances. Hospital Products Limited and United States Surgical Corporation, 1984 is the case to go to for that. Lawyers must act in the best interests of their clients and not take advantage of them. There is also a statutory obligation not to engage in misleading or deceptive conduct under both the Corporation, Competition and Consumer Act 2010 and the state-based fair trading legislation. Have a think about Lawyer X. Which side was she on? There's been lots in the news about that. What do you think about that? In terms of the cab rank rule, this only applies to barristers. It does not apply to solicitors. So if you're going to become a barrister, you need to be familiar with this. And as a solicitor who is briefing barristers, you need to be familiar with this. The cab rank rule lies in the barristers' rules at rules 21 and 22, that they must accept a brief from a solicitor to appear before a court in a field in which the barrister practices or professes to practice. If the brief's within their capacity, skill and expertise or experience, the barrister is available for work, the fee offered is acceptable to the barrister, and the barrister is not obliged or permitted to refuse. A barrister must not set the level of an acceptance fee for the purposes of Rule 21C higher than the barrister would otherwise set if the barrister were willing to accept the brief, with the intent that the solicitor may be deterred from continuing to offer the brief to the barrister. Some barristers in the jurisdiction that I work in family law, don't accept briefs if it's a legally aided client, but they just say they don't do legal aid work, so they don't have to follow this cab rank rule. There's been some critiques about the cab rank rule. There are some mandatory exceptions. Rule 95, there are 14 exceptions. 97 is one of those. Potential breach of confidentiality. 98, they're double booked. Might be conflicts of interest or something around maintaining a client's confidence. Have a look at the study guide and the textbook on these. There's some discretionary exceptions. Rules 99 to 106 of those barristers' rules. They enable barristers to decide whether a brief may be refused or returned. In the study guide, you can have a look at there's arguments against the cab rank rule applying to the solicitors, which include a greater supply of solicitors than barristers, solicitors acting as a sieve, filtering unmeritorious claims. What violates freedom of association? The pursuit of individual projects and goals is integral to the attainment of personal happiness. What works for each of us, and accordingly the collective pursuit of our individual's aims, is at the most key points likely to be the best method of maximising happiness. A central manifestation of the right to liberty is the right to associate with people of our choice. Individuals are permitted to choose the company they wish to keep, whether in a public or professional setting. Not all rights are accompanied by duties. The right to legal advice does not necessarily mean that all barristers must act for a client when requested to do so. Lawyers are indeed the only people who can legally represent others, but not every lawyer must have his or her liberty curtailed to ensure that each person's right to be legally represented is observed. What about economic expedience? There is at least one obvious advantage to this obligation. It insulates barristers from criticisms that they are in some way inflicted with the moral flaws of their clients. The cab rank rule assists barristers in Australia to take unpopular cases. Absent the rule, some barristers could be deterred if such appearances were generally construed by professional colleagues and the public as expressions of sympathy for the client's cause. So again, let's have a look at the unpopular and repugnant clients. Solicitors may reject unpopular and repugnant clients. Barristers, as I said, are subject to the cab rank rule. And the following rules, 2, 4, 5 and 37, who might be regarded as a repugnant client. The answer to this question is an individual decision based on the client's goals and not necessarily the client themselves. The cab rank principle supports professional detachment. Representing unpopular and repugnant clients can attract public and peer disdain and affect income. Defendants facing serious criminal charges have no right to representation. I would like you to focus on the following 3 examples in the notes. Have a look at McInnes, VR 1979, Dietrichs, VR 1992, and New South Wales and Canellis 1994. Have a look at those and we'll have a discussion in the tutorials. There's a duty to continue to act. This is a general rule that lawyers' contract is to finish the entire retainer. Exceptions to the rule are found in Rule 13 of the Australian Solicitors Conduct Rules. So if you have a look at that, these are the reasons why we can stop acting. We've completed it. The case, the file, or the client terminates the engagement, or for some reason you've terminated the engagement. They must ensure the completion of the legal services unless these occur. The client has otherwise agreed that you no longer act for them. The law practice is discharged by engagement by the actual client, or the law practice terminates the engagement for just cause and on reasonable notice, or the engagement comes to an end because of the operation of law. Where a client is required to stand trial for a serious criminal offence, the client's failure to make satisfactory arrangements for the payment of costs will not normally justify termination of the engagement unless the solicitor or the law practice has served a written notice, and that needs to be at least 7 days before the hearing, given appropriate notice to the registrar of the court in which the trial is listed to commence, where a client is legally assisted and the grant of aid is withdrawn or otherwise terminated. You may, as a solicitor, terminate the engagement by giving reasonable notice so that the client's got a reasonable opportunity to make other satisfactory arrangements for payments of costs which would be incurred in the engagement continued. And back in topic 4, when we talked about money matters and liens over files, sometimes you are able to retain a lien over the file because your fees haven't been paid, but very difficult when we're, in litigation. So go back to that if you've forgotten what we talked about. What happens if there's a breach of duty to act? Well, in our previous topic, we talked about disciplinary action. You could be sued for negligence, a loss of payment for work performed prior to the breach. You won't get paid, or a new trial if the client has to proceed without representation. Sometimes it also comes down to reputation. So sometimes you brief a barrister and they do return their brief. Often this happens because they've double booked due to court listing procedures or adjournments or settlements. There are some restrictions to be found in the bar rules about this. In particular, 102, a barrister must not return a brief to appear in order to accept another brief, to appear unless the instructing solicitor or the client in the first brief has permitted the barrister to do so beforehand. And that is only after the barrister has clearly informed the instructing solicitor and or client of the circumstances in which the barrister wishes to return the brief and the terms. In Rule 104, a barrister who wishes to return a brief which the barrister is permitted to return must do so in enough time to give another legal practitioner a proper opportunity to take over the case. You should also study the Barristers' Rules 95 to 106, which deal with the following factors. 95 to 98 is briefs which must be refused or must be returned, and 99 to 106 deal with briefs which may be refused or returned at the discretion of the barrister. Clients have a right of dismissal. Clients are entitled to dismiss lawyers because they lose confidence. For example, sometimes they dismiss you because they think you're not working hard enough, or you're not acting on their instructions, or you're not being their mouthpiece, which you should never be their mouthpiece. You must provide legal advice. Clients must pay for the work done or risk a lien being placed on their files. Solicitors' Rule 15 allows solicitors a lien over essential documents for unpaid costs. If the case is sound, a lien may not be granted by the court. There's also a risk of negligence being brought by the client. When thinking about what documents are owned by a client, refer to Wentworth and Montfort, 1988. The clients have a right to choose counsel. In Collins, Haas and R, 1976, the High Court affirmed the principle that parties to civil or criminal proceedings have a right to present their own case. Are there reasonable prospects of success? Refer to the Bar Rules 63. A barrister must not allege any matter of fact in any court document settled by the barrister, any submission during any hearing, the course of any opening address, or the course of closing address or submission on evidence, unless the barrister actually believes on reasonable grounds that the factual material already available provides a proper basis to do so. Solicitors have the same obligations as well. You can't run a case if you don't think that there's a reasonable prospect of success. So on review, you should be able to know after reading the chapter and considering the study guide material, the rules that govern the question of whether a legal practitioner can decline to accept a case. Appreciate all the ethical dilemmas that are imposed by this. Compare and contrast the rules that inhibit lawyers from withdrawing from a case once they've accepted it. When can they, within the rules, withdraw? And look at the claims that there's been a shift in legal professional practice from a service now to business. So again, some of the main points that we covered, which I believe we started with. So I'll see you all in the tutorial when we get to that. Thanks for listening and see you next time. It always takes me time to turn off my PowerPoint. I'll stop the share and I'll end the recording.